Hello and welcome to tonight's City Club of Boise evening conversation. My name is Greg Hahn. I'm a board member of the City Club, and I'm pleased to welcome you all here tonight. The City Club of Boise brings people together to explore community issues and hear diverse viewpoints by creating spaces where conversations happen. This is possible through the support of our members and our sponsors, and for this we say thank you. Our premier sponsor is Northwest Nazarene University and the NNU College of Business. Our annual sponsor is the University of Idaho. We also receive support from our forum series sponsors, AARP Idaho, Bank of Idaho, the Echelon Group, Optum Idaho, Pacific Source Health Plans, and Small Mind Development. City Club of Boise receives grant funding from the Idaho Humanities Council, the Osher Institute for Lifelong Learning at Boise State University, and the Osher Institute of Lifelong Learning at Boise State University is our community partner. Thank you also to our media partners. These include Boise State Public Radio, the Idaho Statesman, Idaho Public Television, and our university partners, Boise State and NNU. And of course, all our members and individual donors, and I want to remind everybody that this is the last night of Idaho Gives. It's running for 4 days this year, and we would thank you in advance for considering the City Club of Boise as you make your annual donations. As we start every forum, we want to acknowledge the ancestral, cultural, traditional, and unceded territory of the Shoshone, Bannock, and Northern Paiute people on which we are meeting today. The goal of this conversation that we're about to have is to hear from and ask questions of the Republican candidates for Attorney General. We've invited these three candidates here tonight in advance of the May 17th primary election so we may gain a better understanding of their positions and their platforms. We're going to begin with 5-minute opening statements from each candidate. As we've talked about beforehand, this isn't quite a debate. We want it to be a conversation. We want it to be to kind of live in the way that our City Club forums live, where people can talk and listen and learn from each other and probably learn from the audience questions as well. So that's what we're hoping for today. And so, well, I hope the audience members, when you ask questions, keep that in mind. And of course, the candidates as well. They are used to being in big rooms talking to people. So I think this will be easy for them. We're going to focus on your questions after this opening. I've got a handful in case you are shy or slow to put them in, but you can use the Q&A function of Zoom. Just type your question in. Or if you'd rather, you can email it to Morgan. She's at morgan@cityclubofboise.org. morgan@cityclubofboise.org. And she'll make sure I have it. And I will do my best to present each question. I'll probably group some. I'll try to keep them in some kind of order so the conversation can have a nice flow to it. So we're going to get started. The order of introduction and the opening statements, and then in turn the closing statements, which will be the reverse of that, we determined by a random number draw, and they're going to go in this order. It'll be first Mr. Raúl Labrador, then Mr. Art Macomber, and finally Mr. Lawrence Wasden. And I'm going to let them introduce themselves and who they are, because I think you'll get it the best from them. And so I think we're all here, and if we're ready to go, I will send it your way, Mr. Labrador, and hit the start on my timer. Thank you.
Hello, good evening. This is Raúl Labrador. It's an honor to be here with the City Club of Boise. Greg, it's good to see you again. It's been a while. Nice. And I wish I could see the audience. It's a little bit more difficult to have these kind of debates when you can't see the audience, these kind of exchanges. But we're excited to be sharing with you my vision for what the Attorney General's office should be doing. But before I do that, I want to introduce myself a little bit to the audience. I'm Raúl Labrador. I've been married for 30 years. I have 5 children. I have 2 grandchildren and 1 grandchild on the way. I went to BYU and then graduated from University of Washington Law School about 30 years ago. I've been a practicing attorney. Before I practiced law, I was actually a law clerk in the federal courts here in Idaho for a year and a half. And I had the honor of working with the federal court and the federal judges there for a period of time. I started a small law practice a few years after graduation, and I had that law practice for 10 years. During that time, at the last 4 years of my law practice, I was also in the state legislature. And I represented District 14, which is Eagle, Star, Northwest Boise, and North Meridian. Represented District 14 in the House of Representatives. And after 4 years in the House of Representatives, I was 8 years in Washington, D.C. as a congressman for the 1st Congressional District. In Washington, D.C., I was known as one of the staunchest conservatives in Washington. I'm a founding member of the Freedom Caucus. Freedom Caucus, as most people know, is the group that was started by Jim Jordan, Ron DeSantis, Mark Meadows, myself, and many other, and 5 other members of Congress. And what our goal was to hold our leadership's feet to the fire, to actually do what we said we were going to do as members of Congress, to not just make empty promises to our constituents, but to actually follow through on our promises and to stand up for the principles that we believed in. I've now back to being a practicing attorney, and I also work in government relations. And I'm just excited about this opportunity to be sharing with you my vision for the Attorney General's office. We have a problem in Idaho. We I think are in a crisis. We have an Attorney General who has been there for 20 years as the incumbent Attorney General. And before that, he was 10 years as a Deputy Attorney General. And he has changed the way that he works because he believes that his job is to represent the bureaucracy of Idaho. And I don't think that's the job of the Attorney General. The job of the Attorney General is to represent the people of Idaho, to stand up for the rights of the people of Idaho, to stand up for the Constitution, and to ensure that the government, both the federal government and the state government, does not overreach and does not violate your rights in any way. And I want to give you a couple of examples of what that means. In the state of Idaho, over the last 2 years, we have been in a state of emergency. That state of emergency was ended just a couple of weeks ago, but that state of emergency far exceeded the authority that the state statutes give to the governor of Idaho. And you will hear from my opponent tonight that he believes that it was all right for the governor to keep extending that state of emergency because the statute is silent on what that state of how long that state of emergency will last. But that's ridiculous because the state statute, it's actually pretty clear. You have 30 days to issue a state of emergency, and you can extend it for an additional 30 days because this is a power that the legislature is granting to the governor. And it's a power that is inherent in the legislative power that they let the governor borrow if we ever have any emergencies. And this Attorney General who goes around the state saying that he believes in the rule of law, he does not believe in the rule of law. In fact, he believes in giving the governor whatever legal justifications are for his actions. And I think that's why we need a new Attorney General. We also have a problem in the state of Idaho where he's not standing up for the people of Idaho. We have a family in North Idaho that—
30 seconds left, Mr. Labrador.
We have a family in North Idaho. I'm going to share a little bit more about this during the questioning. We have a family in North Idaho that needed the Attorney General to support them, and he did not, while many other attorneys general, Republican attorneys general, supported them. I'm Raúl Labrador. I hope to receive your support, and it's a great honor to be with you.
You dialed it in. That was a quick ending. Thank you so much. We will go right ahead over to Mr. Art Macomber. Mr. Macomber, you're on the clock.
Thank you. It's Macomber, and good evening.
Macomber, I apologize. I'm going to reset your clock. Sorry. Yeah, go.
Many thanks to the Boise City Club for sponsoring this event. My name is Art Macomber, and I'm running to be Idaho's next Attorney General. I'm pro-life, pro-gun, and pro-freedom. And as a Republican, I'm also a 15-year civil litigator who stepped out of the courtroom and into this race because Idaho is in trouble. I am the only candidate running for Attorney General not beholden to special interests, qualified to fight on behalf of Idahoans. And it's time to put the insiders out. The unthinkable happened during the COVID lockdown. The voice of the people was ignored while our civil liberties were criminalized. How much better off would Idahoans have been if they had a champion defending their Article I constitutional rights in the AG's office? How many Idahoans would still have a business? How many would still have a job? How many children would have avoided social isolation and the resulting depression and drug abuse and suicide? Our system of checks and balances failed during the COVID pandemic. Your state executive branch sacrificed your statutory and constitutional rights on the altar of CARES Act funds. Your state legislative branch was stymied by the executive branch in efforts to convene over the summer. And finally, Your state judicial branch suspended jury trials, then lawlessly rewrote legislation subverting speedy trial rights. This election season, Idahoans are looking for justice. Idahoans deserve an AG who will apply the law fairly, especially when that means prosecuting those whom we elected to lawfully govern our republic. In my experience as a litigator, bad actors don't listen until you hold them accountable. The only lawful way to do that is to take them to court. Idahoans are looking for an attorney general with the guts to get the state back on a constitutional footing. I'm running to be your next attorney general because nothing less than the future of our republic is at stake. As your next attorney general, I'll fight executive overreach, strengthen state sovereignty, while protecting Idaho values. These are not simply campaign slogans to me. If I had been your attorney general during the past 2 years, I would have joined the Texas versus Pennsylvania election integrity suit, and I would have sued Mr. Brad Little after he renewed the second emergency proclamation for acting outside his constitutional and statutory authority. Now, these are not radical actions. Our founding fathers anticipated abuse of power. It's human nature, as natural as the sun and the rain. It is shameful to not exercise the constitutional checks and balances Americans have bled and died for to protect. Your incumbent attorney general was the only constitutional officer with the power to stop the abuse of our civil liberties. However, the incumbent failed to protect the rights of the people. He's corrupted by 20 years of cozy relationships with the political insider class. Mr. Wasden must go. But what about my other opponent, the legislator turned lobbyist? He says he'll represent the people, but let's look at the facts. After leaving an undistinguished law career in 2006, the former immigration attorney turned to politics. Over the past 15 years, as I handled over 1,000 legal matters, I'd be surprised if Mr. Labrador handled more than a dozen. But despite his lack of legal experience, moneyed insiders donated hundreds of thousands of dollars to his campaign. One can only imagine what these political sophisticates think they're getting, because they aren't getting an attorney. Mr. Labrador is a political opportunist who will be unable to make good on the legal promises he made during this campaign. Idahoans deserve an attorney with current legal skills in the top legal position of the state. I'm the only candidate running for attorney general not beholden to special interests, qualified to fight on behalf of Idahoans. Let's start with the fact that I'm a lawyer, a practicing lawyer. I'm not a career politician beholden to special interests. I'm a proven fighter. The AG's job is a law job. It's not a policy job. I stepped out of the courtroom and into this race to fight for Idaho. I've studied the Idaho Constitution for 15 years as a practicing attorney, and the US Constitution longer than that in my free time. And finally, I wrote the 2018 Idaho Constitutional Amendment limiting Brad Little's executive overreach. I've been fighting for Idaho already. Now, I want to leave the listeners tonight with just one thought. I do not need this job. I got out of the courtroom and into this race because Idaho's in trouble. The choice on May 17 is simple. Vote Macomber to fight executive overreach, vote Macomber to strengthen state sovereignty, and vote Macomber or suffer the corrupt Boise elite for another 4 years. It's time to put both these insiders out. Vote with other freedom-loving Idahoans and vote for Art Macomber for Attorney General on May 17. Thank you.
All right, thank you. And you must have had your own timer because that was amazingly close to 5 minutes. So nicely done, sir. And I apologize sincerely for screwing up your name, and I will make sure I get that right the rest of the time. Mr. Wasden, you are the last of the opening statements, and I do see some questions coming in. I want to remind the audience that you got 5 minutes to start throwing them to me as you're listening to Mr. Wasden, and go ahead and when you're ready. I can't, I don't
Can you
think.
unmute that? I'm
Oops, there
sorry.
you go, there you go.
Okay. My name is Lawrence Wasden, and I'm the Attorney General. I'm running for re-election, and I ask for your vote. There is a huge difference in this race, and that difference is the rule of law. The rule of law is that all of us are bound by the law, including the Attorney General. This office is not a political office, as some of my opponents have discussed with you tonight. My job is to call balls and strikes, legal balls and strikes, fairly and squarely. That is it a strike or is it a ball? That's how we call it. My job is to represent the people collectively, not individually. That is, we don't represent the individual rights. We don't represent people in divorces or on their land lot disputes or contract disputes. We represent them collectively as a body. In fact, what the Idaho Code says is that the Attorney General's duty is to represent the state and its boards, commissions, officers, offices, and other state entities. It also says that when the governor asks the Attorney General, the Attorney General is required to represent the governor, be the governor's lawyer, give the governor advice, and represent the governor in court. What the Attorney General can't do is sue his own client. That's a violation of the rules of ethics. What the Attorney General can't do is hold a press conference and say the governor is wrong, because that violates the duty of an attorney. So it's often like this. That is, you and I are driving down the road in a car. We happen to see a traffic signal. I notice the light is red. And you ask me, what color is the light? I can give you one of two answers. I can tell you the truth and say that the light is red. Sometimes people will get upset with that. Or I can lie to you and tell you the light is green, and other people will say, oh, yay, you're on our team. The answer is, if I am willing to lie to you and tell you that the light is green, it doesn't change the color of the light. It's still red. And when you drive through the intersection, you're going to get hit. I serve your interest best by telling you what you need to know rather than what you want to hear. Talk for a moment about the Texas versus Pennsylvania case. The question in that case wasn't the efficacy of the 2020 election. Instead, the question was, can one sovereign state, that is Texas, sue another sovereign state, that is Pennsylvania, for Pennsylvania's exercise of its sovereign power? All 9 members of the United States Supreme Court said I was right. Texas could not sue Pennsylvania. That it violates the principle of federalism. Federalism is that we have a national government and we have state governments, and that we have 50 independent state governments. None of those state governments controls another state government. Think about it for a minute. If Texas can sue Pennsylvania, then California can sue us when we exercise our sovereign power. I am the guy who stood nearly alone defending Idaho's sovereignty. It's not just a word to me, but I've paid the political cost of defending Idaho's sovereignty. I also sue the federal government when there's a violation of law. I sued the federal government over the OSHA vaccine mandate and won. Regarding the state of emergency, if the governor asks me to be his lawyer, my job is to advise him as to the law, and then he makes his policy choice. My duty as an attorney then is to present the legal arguments in support of the governor's decision. Whether I agree or disagree doesn't matter. What I don't get to do is I don't get to usurp the governor's authority. I don't get to usurp the authority of the judiciary, and I don't get to usurp the authority of the legislative branch of government. Limited government and the rule of law means that I have to stay within the confines of my responsibility and not try and exercise the duties that are assigned to someone else. In fact, our Constitution says that a member of one branch of government cannot exercise the powers that are allotted to a different branch of government.
You're coming up about 45 seconds.
Okay, so the answer is the rule of law controls what I do. What cases do we join? The ones where there are facts and a law and a cause of action. That's when we join a case. We don't do it otherwise. We don't do it to score political points. My name is Lawrence Wasden. I adhere to the rule of law, and I ask for your vote. Thank you.
All right. Thank you, Mr. Wasden. Thank you all three for that. I think we got a pretty good, clear start to this. We do have some questions rolling in. I want to start though with something that I've been thinking about and I think really came up during these conversations, and that's a little bit about the slate of elected officials at the top, right? I mean, there are times that, you know, where that group of folks are together as the land board. There are times that they're all individually charged with their own particular rules. And I'll start this with you, Mr. Wasden, and we'll give everybody a chance to talk about it and try to, in general today, we'll just try to keep things relatively tight as you can, and we'll just go from there. But how does that dynamic work? I mean, I get the sense that, there are times when everybody needs to work together. There are times when there are obligations not to work together. And I think there's a lot of that sort of interpersonal kind of relations that happen. And I'm just kind of looking for your perspective on that. And then we'll talk to the other two about how they kind of anticipate moving into that space.
Well, I'm not really clear on what you're asking, but I'll do my best here.
I can be a little more specific. It'll help.
Can you be a little more specific?
Yeah, I mean, is it a team of elected officials that are representing Idaho? Is it a bunch of individuals representing, the voters? How do you see your role in that slate of the top elected officials in the state? And then I think the legislature probably plays a role in that as well, in the judiciary, but really with the 5 statewide officials.
The statewide officials have differing responsibilities. The governor is the chief executive officer and has certain powers and responsibilities. The superintendent of public instruction has a different set of responsibilities. Those sort of overlap in some instances and don't in some instances. Other members, the Secretary of State has a very specific set of responsibilities, as does the state controller and the state treasurer. My role as the Attorney General under the law is to be the legal officer, that is to represent those agencies. It is to give them legal advice and to represent them in court. In fact, the Idaho Code 67-1401 specifically says that I'm required to give legal answers to those state officers upon their request. That means I don't undermine them. I don't usurp their authority. I don't make their decisions for them. I advise them. They're an independently elected officer. They make their choice. My job is to then represent them in court and make the legal arguments that sustain their decisions, even if I disagree with the decisions that they make, and I often do. Sometimes we work together. Other times it's independently elected persons who are acting on behalf of the people that elected them.
Thank you. I'll jump to Mr. Labrador because you were in the legislature and could probably talk first about, I want to preface your answer to the question with, that kind of works in the legislature too, right? Legislators often ask the Attorney General for opinions. The legislator then can release those if they want. They don't have to. They can follow along, or they don't have to. If you could talk a little bit about that and that relationship, and then how you see your role, or what the role would be among the leaders.
Yeah, I'll start with your first question to Lawrence first, and then I'll answer that question you asked me. But okay. There are 7 different constitutional officers. They all have individual duties and responsibilities, and they have to work together to ensure that they're representing the people of Idaho well. And they have their own independent constitutional duties and responsibilities. They need to work to do whatever the Constitution and the statutes tell them that they need to do. But I think it's really fascinating to listen to the Attorney General say that he would never sue his clients when he actually sued the land board. He's a member of the land board, and he ended up suing the land board. And now he's saying that he would never stand up when a constitutional officer does something that is unconstitutional, and would never disagree with them. The other thing that I find really fascinating is that he continuously says that the statutes say that he needs to represent the governor. That's not what the statute says. The statute says that he needs to give legal advice to the governor. And the legal advice should be according to the Constitution. Whatever the limits of the governor's power are, that's what the Attorney General should be giving to the governor. And I think a strong Attorney General, which is what I want to be an aggressive Attorney General, should stand up for the people of Idaho. When the statutes say that the Attorney General represents the state of Idaho, they mean that they represent the people of Idaho, that the Attorney General should be the check and the balance on the governor's power, and not justify the excesses of the governor's office or any other executive officer, but actually stand up for the rights and the liberties of the people of Idaho. Now, with your question about the legislature, I think it's important for the Attorney General to work well with the legislature. I do think we have a problem in our statutes that needs to be resolved. The state statutes say that the Attorney General's office gives legal advice to the legislature. I thought that was odd. When I was first elected to the state legislature, I thought it was very odd that an executive branch officer was giving legal advice to the legislative branch. I will work with the state legislature to change that. I think we need to ensure that the legislature has their own attorney, so they don't have to rely on the Attorney General's office. And then the role of the Attorney General is to work with whoever that attorney is in the legislative branch, so the legislation can be written in a way that can be defended in the courts. One of the biggest problems that we have in the state of Idaho is that the legislature doesn't even trust the Attorney General anymore. So they hire their own legal counsel, they ignore his counsel, and they don't work together. And I think actually working together with the legislature, being a better partner with the legislature, will ensure that we don't waste millions and millions of dollars in litigation.
Right. I think I'm going to come back to that issue because it's really fascinating. But Mr. Macomber, I'm hoping you could talk a little bit about how you've envisioned your role with the leaders of the state.
Constitutionally, constitutionally, the officers are separate. They have their own set of powers, and they do have to work together on occasion. For example, the Secretary of State has primary authority over election integrity and assists the county clerks with instructions on how to properly conduct elections. If they have questions, they go to the Secretary of State. Now, in a case of election fraud, the Secretary of State may turn to the Attorney General's office and ask for assistance, either through investigatory power or prosecutorial power, as could the other state officers. But they don't. There's no hierarchy per se. The Lieutenant Governor does not get authorization from the governor to do anything or not, and the same with the Attorney General. Now, there's a little bit of a problem here in that I'm afraid the incumbent is taking advantage of what's commonly called the attorney-client privilege, which exists between private parties, and I've had hundreds of them, that does not apply here as a state official. The reason it doesn't apply here is because the primary duty of the Attorney General is fidelity to the Idaho Constitution and then the federal Constitution. He cannot have a separate attorney-client relationship with the governor because that would conflict with his duty to the Idaho and federal Constitution. And so we need to be quite careful analytically that we don't just simply impose a private relationship on the governor and the Attorney General as may appear in a private situation. It's different, and the Attorney General, when advising any other state officer, needs to be very careful that the Article I rights of the citizens in the Idaho Constitution and then the federal power are respected in that opinion. And if the Attorney General has been doing that and the governor or other parties have been disregarding that advice, then that only speaks to the capability of the attorney themselves not to talk their client into the right direction. And I think so that's just the second problem that we run into. Now, there are only 17 cases in Idaho at the Supreme Court level that even mention the Attorney General statute at Title 67, Section 1401. I do think it is a problem, and I was actually the first one to raise the issue in the campaign. Mr. Labrador is quite good at taking my ideas on the campaign. I appreciate I'm raising the bar for him. But we do need attorneys back in the legislature. They were taken out in 1997. There are a number of duties they could accomplish in a legislative counsel's office. It is proper that the people making the law should have their own attorneys to get an opinion on it before they make the law. The dramatic problem which occurred recently, and I'm frankly surprised this hasn't been noticed and cured before, is that Mr. Wasden's opinion of Senate Bill 1309, the so-called heartbeat bill, was
given straying a little bit here. And well, you go ahead, but as we go down the road, we'll try to I'll call folks back if we get too far off topic. So
well, no. So the point I want to make is that if a legislator went to someone in the legislative branch in a legislative counsel's office, then that opinion could remain secret until the end of session or until the bill was actually voted on or put in a drawer or whatever the legislature is going to do. And that's just assures that there are none of these conflicts of interest.
So I'm really fascinated by the idea that you wouldn't
Greg, I really need to respond to some of these things that have been said. So,
jump in. What I
sure.
was going to
So-
talk about
so-
was the
so first of all,
attorney-client privilege thing is one thing I'm interested in.
yeah,
And
okay.
the
So
attorneys throughout the
Yeah.
structure of
So
government.
first of all, the claim that I said I would never sue anyone, that's not an accurate description of what I actually just said.
I thought it would be a violation of your right.
It's my turn, Raúl. And I did not say that, and you misquoted what I said. It's true that I sued the landlord, and if you've read the cases on that, you understand that is a very specific and unique duty to the Attorney General only. It is not out in the public. It is a specific duty of the Attorney General to enforce the requirements of both public and private trusts. And it's under that very specific authority that I sued the landlord, because they were violating their constitutional duty. And the Idaho Supreme Court agreed with me and specifically said, this is the duty of the Attorney General. So I did specifically and exactly what my job was to do. By the way, the provision that Mr. Labrador quoted, saying his job is, the Attorney General's job is only to provide advice, is not accurate. That's not what the Idaho Code says. Idaho Code section 67-1406 says that upon request, the governor is entitled to use the legal services of the Attorney General. Legal services is advice and representation in court. It is not just simply to give advice. The claim that the legislature doesn't trust the AG, there are certain members that don't want to listen to my advice, and they regularly don't. But to say that the entire legislature is that way is not accurate at all. We regularly help legislators prepare legislation, help them write it, and help them present that legislation. We need to talk about the issue of attorney-client privilege. And the fact is that the legislature recognizes the attorney-client privilege between the Attorney General and its members. Now, I can't waive that. That's what the law is. And the law also recognizes the attorney-client privilege between the executive officers and the Attorney General. The Attorney General doesn't have the ability to waive that privilege. It isn't a conflict with my respective duties. It is specifically complying with my respective duties. And in fact, with regard to the mention of Senate Bill 1309, the answer is I am asked by a member of the legislature, and the law says that I am required to give them a legal opinion upon request, which we did. It's up to that legislator whether they want to disclose that opinion or not. And in fact, that legislator chose to disclose that opinion. And that is their free choice as a client. With regard to legislative counsel's office, the legislature can and does regularly select outside counsel. So I'm not sure why that's a bit of an issue. The answer is that they're free to do that. The law specifically allows them to do that. And they by law have said, and this is the duty of the Attorney General, which it's their constitutional power to do, to say I'm required to give them an opinion in writing upon their request. So all I'm doing is specifically what the legislature said I am to do, exactly what they've said.
Greg, I need to respond.
In this neck of the woods, and I want to ask you first, Mr. Labrador, to respond, but also, and to talk about specifically that attorney-client privilege question. I think that's a fascinating question about whether that exists between an attorney general and the governor and other members of the leadership team in the legislature.
You know, here's the problem that we have is that he continues to misrepresent or misunderstand. Actually, it's not even misrepresentation. It's misunderstanding of what the responsibilities are of the Attorney General, which is sad because he's been doing this for 30 years. And I don't know if he started with this 30 years ago or just because he's a bureaucrat now after 30 years in the office that he's changed the way that he represents the Attorney General's office. The role of the Attorney General is more like the role of the legal counsel on a board, where you give legal advice, you give your legal services, you talk to the board about the things that you have to do and the limits of their power, whether they be under, you know, whatever their governing documents are. We know that the governing documents of the state of Idaho are state constitution, the federal constitution, the statutes, and the regulations. That's what the Attorney General should be doing, is giving the legal advice to the governor, to the agencies, to the boards that he serves on, to all the different things that they do. They're supposed to be giving that legal advice, but they're not the personal representative of the governor. And he keeps misrepresenting that and misstating that. And it is very possible he just doesn't even understand that the role of the Attorney General is not to be the personal attorney for the governor. That's a different responsibility. The governor actually has their own personal attorney, and that attorney needs to represent the attorney. They can sue the state. They can do all those different things. He just stated that he sued the state when he felt that the land board had violated their constitutional rights, the Constitution of the state of Idaho. That's what a good Attorney General does. I actually think that a good Attorney General should stand up to the overreach and whatever overzealousness of the state government. And I think a good Attorney General would stand up to the governor, would stand up to any government agency that is violating the rights of the people of Idaho. So I just find that really fascinating that he thinks he's the personal attorney of the governor when nothing in the statute says that he's the personal attorney. He has a different role and responsibility. He's got a fiduciary duty to the people of Idaho. He's got a fiduciary duty to the Constitution, and he's got a fiduciary duty to the statutes. And that's what an Attorney General should be doing, is standing up. And if you were a good Attorney General, the people would be listening to you. And then you say that the legislature does trust you. The legislature just hired their own counsel to represent the state of Idaho in the abortion case. The state legislature tried to take away many of your responsibilities. In fact, a couple of years ago, they tried to defund your entire department. So for you to stand here or sit here and tell the people that are watching this that the legislature trusts you, the evidence actually speaks to the contrary of that.
Let me ask you, I'll start with you, Mr. Labrador. What is well, first I want to ask just specifically about what is the Attorney General's responsibility then to the governor? If that relationship isn't there in a legal sense, is the Attorney General brought in on these big questions, or is it completely outside? Is it just sort of
brought in anytime the governor has a question, or the lieutenant governor, or any of the agencies, or any of the executive officers? They need to come in and give legal advice. But remember that the Attorney General, the first thing that they do on their first day, they take an oath of office to protect and defend the Constitution of the state of Idaho and the Constitution of the United States. It's very important that the Attorney General understand that. This Attorney General thinks that the oath that he takes is to the governor, and that's just wrong. The oath that you're taking is to the Constitution. You don't have this attorney-client privilege. Nothing in the statutes talks about that attorney-client privilege. Now, you have to work within the rules of ethics, and I think that's very important. But it's not the same kind of relationship. I mean, think about it this way, Greg. If you had a board that was given legal advice by their attorney, and one of the members of the board, and I'm talking now about an outside board, in the private sector, one of the members of the board violated something in their governing documents, the attorney for the board doesn't represent that individual. They have to go find their own attorney to represent them. That's the relationship that this Attorney General has to the government agencies, and their number one responsibility is to work on behalf of the people of Idaho. That's why it says the Attorney General shall represent the state of Idaho, which to me, it means the people of Idaho. To him, it means the bureaucracy of Idaho.
Greg, I think I can put some light on the subject here. As we stated in the very beginning, these state officers are all separate. They all have their own separate responsibilities. They're not beholden to each other. And there is nothing in the statutes that says that one becomes the client of another by rendering an opinion. And so there are a couple of things going on that should be recognized. If the Attorney General renders an opinion to the legislature, that would happen under Idaho Code Section 67-1401, subsection 6. If the legislature asks for opinion, then he has to give it. But remember, all of those opinions are to be published and printed. It doesn't say when they're to be published and printed. And so the question is, how do you protect those opinions while the law is still being made before the governor vetoes it or approves it or whatever. And so what we have to consider is that all these opinions are subject to public records requests, which means there cannot be a functioning attorney-client relationship as like a private client. And when Mr. Wasden says, I represent the state, what that means is that the state is the client, including the people, because the state includes all of those. And so the difficulty becomes if someone asks for an opinion from another state office or the legislature, be it the governor or the secretary of state, doesn't matter. First of all, recognize that the two constitutions have to be accounted for in that opinion. And that opinion is going to be subject to public records request almost immediately. And unless there are safeguards for it to protect other operational concerns of the Republic. For example, as I mentioned, an opinion given to the legislature should properly wait until the law is created or dispensed with, or the session is over or something, before it is subject to a public records request. And there are numerous exceptions in the Public Records Act at Title 73 that I think would allow that.
Greg, I've got to respond to a number of those things. I'm not sure that I can write them all down and respond to every one of them. But the fact of the matter is that every attorney takes an oath. And one of the things that that attorney promises is to hold inviolate the confidences and secrets of his client. As an attorney general, that ethical duty is incumbent upon you, upon me. But I have that responsibility to do that for my clients. And in fact, Idaho Code Section 67-1401 says that I am to do two things: give legal advice and represent in court all the state. And by the way, the Organic Act passed by Congress created the state as a separate legal entity. Do I represent the people? Yes, I represent all of them collectively, not individually. I don't just choose among the people which political viewpoint I'm going to represent. If I was to do that, if I was to undermine the governor and countermand what he does and countermand what the legislature does, I then become the king. I'm the guy who has all the power because I can choose which of those policies I'm going to pursue and which I'm not. The Attorney General is not the king. The Attorney General's responsibility with regard to that advice is to advise, allow the client to make their choice because they're imbued with constitutional and statutory power to make a decision, and then to provide the legal arguments that sustain that policy choice made by constitutional officers in the legislature. That's what the Attorney General is supposed to do. It's not supposed to render all power and undermine the decisions, even if they're wrong by other entities. By the way, I didn't sue the state in the land board case. I sued the land board itself. I think it's it says the land board, Wasden versus the land board. I think that's what it says.
But you represent the land board, right?
Greg, you can
Absolutely,
precisely.
absolutely.
You're
You
on the
represent
land
the land
board.
board, so you sued your client.
The issue that was
Actually, I
raised
sued myself.
It begs the question, who is
I
the
actually sued
client?
myself, and the court said that's exactly what you're supposed to do as the Attorney General with regard to the land board, because it's a very specific duty. That is the only person in the state who holds that duty is the Attorney General, and it's the duty to see that the terms
But Greg,
of private trust are carried
here's
out.
what Mr. Wasden just said begs the question of who is the client. Is the client the governor when it's the governor, or is it the state of Idaho and the governor at the same time? Because you can't serve two masters. And so when advising the governor, the primary and only client has to be the state of Idaho. And so that if the governor steps out of bounds constitutionally or lawfully, he is in that act no longer the governor. And I think the Attorney General has to rein him in on behalf of the state of Idaho. He's going to say no, but I'm going to say yes.
Well,
Greg,
Mr.
it's
you
really
actually said-
It's really important to know that he keeps saying that he's bound by the law, he follows the rule of law, but that's not true. And I'll give you a very recent example. He claims that his job is to represent the governor or whoever asks for legal advice. The governor and the lieutenant governor were in the middle of a constitutional crisis just a few months ago. The governor decided that he could do his job outside of the state. And in that job, he decided that he did not have to do anything, that the lieutenant governor did not have to act. Our Constitution is super clear. Our Constitution clearly says that when the governor leaves the state, the lieutenant governor becomes the acting governor of the state of Idaho. And I say this as somebody who didn't always like all the actions of the lieutenant governor when the governor was outside of the state, but it doesn't matter what I think. What matters is what the Constitution says. And the Constitution is clear. You leave the state as the governor, the lieutenant governor becomes the acting governor of the state of Idaho. He gave legal advice to the governor that it would be fine for him to act outside of the state, that it would be reasonable for him to act outside of the state. That wasn't his responsibility. His job was to look at the two constitutional officers and say, hey guys, governor, lieutenant governor, the Constitution says X, and you have to act according to what the Constitution says. In fact, he says that he doesn't undermine the elected officials. He did undermine the lieutenant governor because he thinks that his job is to be the attorney for the governor. And that's not the job of the attorney general. The job of the attorney general is to stand up for the Constitution.
Mr. Wasden,
Greg,
I'm gonna give you a shot at that. Yeah, let's talk about that moment.
Yeah, that's some folks that, aren't really reading the statute. And the answer is, the law says that I represent the governor. When he asks, I'm his attorney.
And the lieutenant governor.
Whoa, Raúl, I don't interrupt you. You got to have a little bit of common decency. And the answer is the statute says that I represent the governor if he asks. And he asked. And Mr. Labrador was not present when we gave advice to the governor. We did write a memo. And the answer is this: the language of the Constitution says when the governor is out of the state, the lieutenant governor acts as the governor. However, across the nation, other constitutions say similar things. And there are two lines of authority with regard to that language. Some of them say it's physical presence. That is, when the governor is absent from the state physically, the lieutenant governor becomes the governor, or the acting governor. And there are other states who say that same language or very similar language means it's practical absence. So as a lawyer, what you do is advise your client. You say, here's the language, and here's the two different ways in which courts have interpreted that language. You, as the client, you get to determine which of those you're going to pursue. And I don't get to take that choice away from the governor. And it's the same way that your private lawyer advises you. And he says, well, here's two different interpretations of that language. I can only tell you which of, I can make the argument, you're the guy that has to choose. That's the same thing that the lieutenant governor had to do. That's the same thing that the governor has to do. It's the same thing that the legislature often has to do. My job isn't to direct them or control them about what decisions they're going to make. That's just an impossibility.
Is there a line? Is there is there a moment where you think you would be, I got to do something about this? Or is that just not, I guess that only came up to me because thinking about this situation, right? It's like, obviously there's a lot of gray areas. I mean, I imagine there are moments where you might look at a situation and say, this isn't gray anymore.
There are times when you say it's not gray anymore. When the facts and the law say that, and sometimes you have to tell your clients that. I've had to tell them, look, I can't represent you on this because of what you're going to do is clearly in violation of the law. So my duty is to make the legal arguments if they can be made. There are instances when you can't make a legitimate legal arguments in defense of your client.
But in the state of Idaho, in the state of Idaho, Greg, the controlling law is Idaho law. We don't give advice about what the Namibians or the Ethiopians or the English, unless we're looking at common law, or the South Americans or any other state might care about that language. The language that is in the Idaho Constitution is the plain language. It controls unless the people change it. The people didn't change it. So to give an opinion based on some other state, there were, I think, 7 or 8 states that the Deputy Brian Kane brought up about the absence from the state question. The absence of the state is plain language when you're gone. It's not, I'm on a boat in Florida and I have my cell phone, so I can still legislate as governor and do my duty. But if I go scuba diving, then I'm clearly absent because I can't reach my cell phone. Okay, that's not a good interpretation. That is not Idaho law.
And Greg, the answer is the entity that gets to decide what that law means is not the Attorney General, and it's not my two opponents. It's the court who gets to decide that. And if I decide that I'm going to impose my view of that, and I have a specific view of that, but if I impose my specific view of it, I'm actually usurping the authority of the court. So my client gets to choose, and they get to choose how they're going to exercise their duties, and they also accept the legal consequences of the choices that they make. But I don't get to take away their authority to choose.
The state Supreme Court has never ruled on the absence of the state issue, to my knowledge. And we don't take advice or give advice based on other state laws or other state meanderings. Other states have completely separate and different bodies of law from Idaho. If you make an argument on Florida law or Illinois law or something like that, even if that language is the same, it doesn't mean the context is the same. It also doesn't mean the Constitution is the same. And so, this idea that you would be giving a complete legal opinion based on comparable views from other states is an improper way to analytically approach Idaho law and give an opinion.
Greg, that actually would be malpractice to do what Art suggests. And that is that the controlling law is Idaho law, but other states who've made similar decisions are used as ways of helping the Idaho court make that choice. And to ignore those decisions in other states would be in fact malpractice. And so you advise your client, they get to choose. The entity who ultimately says what the law is in Idaho is the court. It's not the Attorney General.
Let me jump back to something that's come up a couple times. The sort of spread of, an Attorney General sort of being in its space and the governor having its outside counsel, which, there is usually one attorney in the governor's office that sort of handles that. But still a lot of reliance, of course, on the Attorney General. There are then I say that, but every governor, every executive office agency has an Attorney General represented within that agency, and that goes throughout the whole space. There's a fair amount of coverage from the Attorney General in that area. And then the legislature kind of building their own out. Starting with you, Mr. Labrador, is that kind of where we're headed? Is that where you'd like to see Idaho go, is to have sort of really more entrenched, I guess, legal teams throughout all of these areas? It just, I think back to 25 years ago when, certainly when I started and a couple of you were in the State House all the time, I think that was, the economic piece of that, the cost of that would be something that some of the old guys would have wondered about. But is that needed at this point? Is that where you hope things end up?
So there has to be a reform of the Attorney General's office, and I can only tell you what I think needs to happen. I'm going to study the issue a little bit more in depth once I win the primary. But the reality is that I think the legislature needs their own attorney. And I have thought that I'm glad that my other opponent thinks that he gave me this idea, but I've been talking about this since he was in law school. He looks older than I do, but I was actually a lawyer in the state legislature when he was still in law school. And I was talking about this issue way back then. And we need the legislative branch to have their own attorneys. The question about the executive agencies, that's a separate question. And we need to look at which agencies need to have their own attorneys and which agencies do not need to have their own attorneys. And I think for the most part, we don't need to change a lot there. But I do think we need to change the culture of the Attorney General's office, because as you have seen, and he repeats it again and again, and this is the biggest difference between me and the current Attorney General, he thinks his job is to legally justify whatever the bureaucracy wants to do. I don't think that's what the job of the Attorney General is. The job of the Attorney General is to let the agencies know what the limits of their power are. One of the reasons the legislature doesn't trust the Attorney General's office is because they pass legislation that limits the power of the agencies, and those agencies do not do anything to actually act on those laws, and they're getting the legal advice from the Attorney General's office that is not helping the legislature actually limit the power of those agencies. I think a good Attorney General who follows the Constitution of the state of Idaho and the Constitution of the federal Constitution will ensure that these agencies understand when they're overreaching. The whole purpose of government is to ensure that the rights of the people of Idaho, it's both in the federal Constitution and the state Constitution, that the rights of the people of the state are protected. And that's what an Attorney General should be doing. And I think when you become a bureaucrat, like our current Attorney General has become over the last 30 years, then you start thinking that your job is to actually give more power to the agencies, more power to the government, and to legally justify how they can actually have more power. I don't think that should be the job of the Attorney General at all. So I will be looking at every one of the agencies and ensure that they're getting the right legal representation, and that the Attorney General and the deputies in those agencies are providing the good legal counsel.
So are we talking about a fourth role of government?
That's just nonsense. That's just nonsense. My job isn't to expand the power of agencies. The agencies don't determine the extent of their own power. The legislature determines the extent of that power, and that's precisely what we do. Actually read the statute and do what it says. I'll give you an example of that. This is a way old one, but when I was first elected as the Attorney General, there was a big fight in my own neighborhood about a charter school. What the statute said was the charter school had to file its application in the first instance with the local school board. They hated the school board, and that school board hated them. There was a personality conflict. And so there was a lot of pressure to allow the charter school to file its application in the first instance with the State Board of Education. In fact, members of the state board called me and said that's what they wanted. And so we just opened the statute and read it. It's written in English, must file in the first instance with the local board, and if denied, can appeal to the State Board of Education. And so that's what we said, exactly what the statute said. Members of the state board started screaming, we're going to get control of the Attorney General because he's not giving us the opinions that we want. The answer is, I don't give them opinions that they want. I give them the opinions that say what the law is, not what they want to hear, what they need to know. And that's precisely what we've done from day one. And so this is just nonsense. Long on complaint, short on facts.
Greg,
Sorry about, I apologize for the sound that just kind of popped in. I'm in a shared office space, so I had to.
That's all right. No,
Greg, I've given you
there's
two
a very
or three.
simple view of this here with the attorneys in the legislature, et cetera. If you just consider all three branches, it makes much more sense to avoid conflicts of interest and separation of powers problems by having the legislature have their own set of attorneys. That means the Attorney General's office itself has to give up some positions. We don't know how many positions until we get there. But in terms of having the agencies have their own legal counsel outside of the AG's office, I think that would be a bad idea. Because when the ordinary citizen encounters the executive branch, they should have much the same procedures to move through all or any of the agencies. And so you can't let the Department of Lands go one way and Health and Welfare go another way with their own outside legal counsel, or really even their own inside legal counsel. Part of the job of the AG is to make sure that there is a set of rules across the agencies that allows the Idaho citizen to do business with the state of Idaho in an easier fashion. And we have 720 sets of executive branch rules in Idaho today. And that's another reason for putting attorneys in the legislature as a separate office, is because during the off session, they could actually review those executive branch rules and use the 2018 constitutional amendment that I wrote at section 29 of Article 3 to make sure those IDAPA rules, those executive branch rules, actually comply with the statutes that were passed. That appears not to have been done in quite a while. They look at the new rules when they come into session at the legislature, but there's been no review of that body of rules. And so there are a number of tasks to get this right. But I don't go along with the idea that the agencies should have their own counsel outside of or even siloed inside the AG's office. They need to be talking to each other and working with each other, just even if it's only on procedure, to make it easier for citizens to do business with the state of Idaho.
Well, I guess my question is, how do you do both of these things, right? How do you have independent, essentially fourth arm of government, right? That's not part of the executive branch, that is a check and balance on the legislature, on the governor. But then
I'm
also
not sure why you
teamed up.
keep calling it a fourth branch of government. The deputy AGs are part of the executive branch. So I don't see any way that they're the fourth arm of government, unless I'm misunderstanding what.
Well, I get, okay, so, but
Yeah.
I think it's about how do you treat, or yeah, what is the role of the, I guess would you separate out the deputy AGs then from sort of running the main office and keeping the,
Let me,
you know,
I
let
think
me-
you're getting
I think
caught
let
up
me
in-
help you out. I've got enough history here that I can talk to you about what the history is.
I apologize for most of my legal knowledge coming from, you know,
Okay.
Ally McBeal, but I try.
So, yeah, don't listen to Ally McBeal because that's not an accurate representation of the law. First of all, the legislature determines where how many deputies there are, and it determines whether they are responsible to the legislature or not. The Attorney General doesn't get to put attorneys in the legislative branch of government. It is a separate branch of government. They make that determination on their own. The Attorney General doesn't decide that. Well, let's go back in history to about the 1930s, and there was a consolidated office of the Attorney General. The governor was of one party and the Attorney General was of a different party. And I don't remember who was a Democrat and who was a Republican, but they got mad at each other. And the governor had great influence in the legislature and it was his party in power. So they then bifurcated the office of the Attorney General. So it used to be that there were a central office attorneys general, and then there was agency attorneys general, and then there were private attorneys that were not part of the office of the Attorney General and were hired by the agencies. That's the situation that we had. Under that scheme, we ended up with cases in which one executive agency would sue another executive agency. Now recognize what's going on there. You, the taxpayer, are pulling dollars out of your pocket and you're paying for the lawsuit and the lawyers on both sides. That's what happened. And the legislature didn't like that. So in the early 90s, they reconsolidated the office of the Attorney General. This is the legislature's choice. And it was signed off on by Governor Bath. And the answer is that they consolidated the office of the Attorney General. They reduced the cost of legal services to the state. And that's the system that we now have. The Attorney General's job isn't to change that system. It's to operate within the system that is designed and set by the legislature. Quite frankly, if the entire legislature hated me as seems to be indicated, why didn't they change that? They haven't done it. And the answer is because there is certain reasons why you have a consolidated office. Art happens to mention one of those, and that is because you then end up with one set of legal advice going to all clients. We do have conflicts between agencies. When that happens, we sit down and make a determination as to what the law actually says, advise both of those agencies. And if there's a problem, we then call on the governors and say, Governor, these are your executive officers. You're the one who's responsible. You need to determine what standards you want to apply. And that's how it works.
Greg, I think what my plan would envision would be getting rid of the separation of powers conflict and taking what is now the Legal Services Office in the legislature and expanding it to allow attorneys to give opinions to legislators before the law is created. That would be one primary task. Now, those positions, in my view, would come out of the AG's office because they went in there one time. Well, they can come out. I'm not sure, without measuring workflows and actually analyzing the organizational demands, how many attorneys that would be. But I think when I spoke to Senator Winder about it last year, he was concerned, as all of us should be, about the growth of government. We don't think there should be a penny spent additional. What we think is that the legislature should have its own set of attorneys in-house and that the other agency legal advice would stay in a consolidated attorney general's office, because those branch agencies are executive branch agencies. And so their legal counsel should be in the executive branch. It's really not that tough a thing, but it would very much reinvigorate Idaho's republic by clearing out some of these problems.
And again, Greg, that is not an attorney general's choice. That is a choice of the legislature.
right?
No, that's right. The
what's the
legislature would have to do it, and you would have to be a good enough attorney to see the problems and actually be able to explain it to the legislature in a way that would assist them in seeing the benefits of it, so that they could do it, because they would have to pass statutes to make it happen.
Mr. Wasden, how big is the office? How many deputies are there?
About 120. We have a total complement of about 230 people.
Okay, and of that split, how many would you say are like in the core office as opposed to split off among the agencies, the attorneys? Do you have that broken down?
No, because it's not really accounted for in that
Gotcha.
way.
Okay.
And so what happens is when a member of the legislature asks a legal question, because we have a consolidated office, we have a central point that question comes through, then we farm it out to whatever area has the expertise to answer that question. For example, someone who has expertise in property tax or income tax or state purchasing or something like that. We farm that out to a person who has that level of expertise and advises their client based upon what the law is, not based upon what politics are.
And Mr. Labrador, you were right in questioning what I'm talking about with the fourth branch of government, because obviously there are different we've seen it in the last few years that the governor and the lieutenant governor aren't always on the same page, even though they're in the same branch of government. That's been true when they're of two different parties. It's recently been true when they're in the same party. And so this is, I guess that just really briefly, it's sort of, that's kind of the subtle nature of what you're talking about, is there's being the attorney for the executive branch of the government, and the attorney's office for the executive branch of the government. And then there is this extra bit of checks and balances that you're talking about. It feels like there's a balance there that would have to be found.
Yeah, I agree.
Yeah. All right, let's do something different. I'm going to start this with Mr. Wasden. That was just enough of a nerd about how this stuff works to be really fascinated by it. But let's talk. This is a good question, and I think it makes sense that we've sort of the incumbent ends up on the getting discussed a lot. But I want to start with you, Mr. Wasden, and talk about consumer protection. One of our audience members asked, to ask you, what are some wins? Where do you think that you've really done a good job for the state? Are there some specific answers? And for Mr. Labrador and Mr. Macomber, when you're thinking about this, how do you view the consumer protection role of the Attorney General's office, and maybe what some opportunities you see down the road for that? So go ahead, Mr. Wasden.
Well, we just completed negotiating settlements to 3 opioid cases and brought $120 million to the state of Idaho, to the state and to county governments, city governments, and regional governments. So you want to win, there's a win. We returned $7 million in restitution last year, $7 million to Idahoans who had been defrauded, Idaho businesses and Idaho citizens. That's a win. We handle numerous consumer protection complaints. So when you ask about wins, there's some wins.
Yeah, well, that was fast. What do you think, Mr. Macomber? How do you view consumer protection and the role of this?
Well,
it's probably the least sexy side, right? It's a non-political daily grind of looking out for the people.
Yes, consumer protection cannot only be telephone scammers and opioid abuse and this type of thing. For example, when I look at the organizational chart of the Attorney General's office, I'm wondering why the Department of Health and Welfare is not blended with the consumer protection, because people receiving medical services in the state of Idaho that are being paid for by a third-party payer like Medicaid by the US government, I think that presents a consumer protection problem of great magnitude. In a standard case, if I hire a contractor who says he's going to build me something and he builds me something else, and if he does this as a continuing ongoing practice, then the Attorney General's consumer protection role surely kicks in. But what about the people that are receiving medical advice and medical information? Excuse me. For example, during the COVID period with all these vaccines, that is clearly proving to be incorrect on many levels. And so where's the
In what way?
consumer
What do you
protection
mean?
there?
What are you talking, what's been proven to be misleading? I'm just trying to keep track.
Well, sure. As you know, Johnson & Johnson was given a step down approval by the FDA. They said, well, we don't want you giving that vaccine right now because of the negative results we're getting. People that have gotten the second and third and fourth boost are the ones that are now having the myocardial problems, and the VARS information coming out on those on that vaccine outcomes are very bad. And so that has to be a consumer protection issue, if anything. And so getting back to it, I think the consumer protection mandate is a lot wider than perhaps it's traditionally been stated to be.
So would you take aim at the Department of Health and Welfare or the Medicaid offices? That, I mean, a lot of that is run through the state, obviously.
So I would certainly look at it as a consumer protection issue. If I am one of the most vulnerable Idahoans on Medicare, or I'm sorry, Medicaid, and that roster has grown significantly since Obamacare was allowed into Idaho, then those people are really the target of the consumer protection activities of the AG's office. As a state agency, when Department of Health and Welfare is doling out funds from a third party to pay for medical care, these are our most vulnerable citizens. And, you know, I could go hire another contractor on a job, or I could go get a new painter, no problem. But for somebody who's giving me medical care, and I really am living day to day, paycheck to paycheck, just eking out a living, that's when you're on Medicaid, that's part of the determining factor is your low economic status. I think we have to look at that as a consumer protection issue.
All right, interesting.
Greg,
Mr. Labrador, let me have Mr. Labrador talk about his, and then we'll give you a chance to sort of summarize, come back at it, because I imagine there'll be some more things, but we'll just keep this discussion going for a little bit. Mr. Labrador.
Yeah, consumer protection is obviously one of the most important roles that the Attorney General has in the state of Idaho. I think it's an important role in the office, and I see it very similar to what I did in constituent services as a congressman. Obviously, this is more through the legal system, but in constituent services, we had a lot of people who would call our office and say that they were having problems with federal agencies, and we returned a lot of money to them. We helped them get millions and millions of dollars back because we listened to them, we called the agencies, and we were able to follow the rules and the regulations and the statutes and ensure that they received money from the federal government. This is a very similar role, but this is under the state statutes and the state codes on consumer protection. You get to go against these different bad actors that are violating the consumers of the state of Idaho. And I think it's something that I've had experience with, and I think it's something that I would gladly, it's going to be a fun part of the job.
Okay, yeah, Mr. Wasden, jump in.
Right. The question you posed to me at the outset was, you know, what are some successes?
That's right. It's a different question.
It's a different question than what you've asked the others, okay?
Yep.
And one thing I failed to mention is the $22 million in tobacco money that we have brought in. That adds up to more than $500 million since 1999, I think, that we brought in to the Millennium Fund. Now, the issue concerning consolidating the Department of Health and Welfare with Consumer Protection. Health and Welfare has a very specific set of responsibilities. There's a lot of federal law that's involved in what they do. It is not a good mix for consumer protection. There is, in fact, a Medicaid fraud unit that we have, which is separate and apart from everything else that looks at those very issues when there is Medicaid or Medicaid fraud. So that structure does not make any sense really to consolidate those two things. The statutory structures that they operate under are vastly different. And we do take into account the information that is flowing to those two agencies. So I just wanted to make sure that we understood why those things are separated the way they are.
Thank you. So
Yeah,
we've
Greg,
got,
I think the Medicaid
Yeah.
fraud unit takes care of fraud on Medicaid by patients in the Medicaid system. What I'm talking about is fraud by Medicaid providers that are taking advantage of the low-income Idahoans on Medicaid. Now, maybe I'm wrong. Maybe
Yeah, you're wrong.
Mr. Wasden will step up and say, no, the answer is.
Yeah, the answer is that we sue Medicaid providers, service providers often.
Okay.
it kind of goes both directions, I think, on that, in that group. If I remember from my old legislative coverage days. All right, we got about 15 minutes left. I'll do sort of a shorter question and then we'll probably need to get into some final thoughts here. But some folks have asked about, you know, collaborating with the other attorneys general. What's the sort of, how do you see the role on a national stage? Are there some individuals that you like the way they operate and you're sort of you would be looking forward to, or in your case, Mr. Wasden, that you enjoy working with on that stage and sort of teaming up on things? And I guess I'll start with you, Mr. Macomber, if you want to talk about what's the role of this job really in the big picture, the big national picture.
Well, in 1832, James Madison was faced with the North Carolina legislature that wanted to nullify a federal law. And he wrote a response based on a concept of intercession, where the state attorney generals, the states themselves, would need to get together to make sure the federal government stayed within its bounds. And that if one state could nullify, then obviously we would have a patchwork quilt of federal law. And so the proper role of a state AG today includes getting together with the other attorney generals from the states and making sure the federal government doesn't break out too far from its cage. Now, of course, it has in the last 80 years. And so the proper role would be to help put it back into the cage that it has escaped from.
Yeah, Mr. Labrador.
You know, I think this is one of the most important roles that a good, aggressive attorney general could participate in, and our attorney general has decided not to be as active in this area. We have a number of Republican attorneys generals that are doing really good work throughout the United States, and they're coming together to fight what I consider to be the greatest fights for the soul of our nation and our state are happening in the federal courts. When you watch the Biden administration that continues to overreach, continues to violate our sovereignty, continues to do a bunch of things that the people of Idaho do not want, that the people of Idaho are opposed to. And I think a strong, aggressive attorney general would join with those Republican attorneys general and fight. It's one of the most interesting things about this race is you have our current attorney general is praised continuously by Democrat attorneys general because he's passive in his role. And they love the fact that he doesn't sue the Biden administration. In fact, the attorney general from the state of Washington praised them for not joining several lawsuits. But that same attorney general sued the Trump administration about 80 or 90 times. And so, of course, he's happy when our current attorney general doesn't sue the Biden administration because he doesn't want strong, aggressive attorneys general, especially one of his neighbors. So I think a strong, aggressive attorney general would make a huge difference in the state of Idaho. Just today, there was a letter that was sent by 20 Republican attorneys general that were trying to fight against this disinformation board that the Biden administration started. Our attorney general did not join that letter. It's not going to, so it's really unclear whether he cares about the issue or not. These are issues that are important to the people of Idaho, but most important, they violate the sovereignty and the rights of the people of Idaho. I think you need a strong attorney general that will understand that he wants to stand up for the people of Idaho. That's like the family I was talking about in North Idaho. They bought a piece of land, the EPA sued them, and 21 Republican attorneys general joined the family in the lawsuit. They filed an amicus brief. For 10 years, this family has been fighting, has gone up to the Supreme Court twice. And our Attorney General decided that he wouldn't even stand by their own family. He wouldn't even stand by an Idaho native citizen. He just joined the lawsuit now because I've been talking about it for about 4 or 5 months. But the reality is that he had 10 years to join that lawsuit, and he decided not to join in any way, in any role. I think that's a mistake. I think whenever the EPA or any state, any federal agency is trying to violate the rights of the people of Idaho, you need a strong Attorney General that will stand up for that.
Mr. Wasden, why don't you talk a little bit about this role?
Sure. You asked, your actual question was, do you join with other AGs or not? And there was a whole bunch of other discussion here, but we'll get to that. The answer is yes, if you can. Now, there are some members, some attorneys general who are former members of Congress. They were failures in Congress, and they've now joined the AG's ranks, and they think that their job is to be a congressman in attorney general's shoes. That's not the function of an attorney general. The separation of powers issue exists between the federal executive and the federal legislative branch of government. The attorney general's role comes when there is overreach by the federal government in the sovereignty issues against the state. Not every issue that comes down the pike is that character. But the answer is, when we have had a lawsuit against the federal government, we have sued the federal government. We're not afraid to do that. We sued them over vaccine mandates. We filed 3 of those lawsuits. 2 of them have been to the Supreme Court. We won in the Supreme Court on the OSHA case. With regard to the letter today, we're actually preparing our own letter because this is an issue, again, where Congress has the primary responsibility to push back on the administration. And we have, as AGs, a secondary role, and we have serious concerns about what's being proposed. But that doesn't mean we necessarily agree with all of the things that 20 other state AGs said, so we're preparing our own. So let's talk about the North Idaho lawsuit, the North Idaho case, this couple up north. This happened when my opponent was in Congress. And not only did he fail to take any action, when he had the opportunity to vote to repeal the WOTUS rules that are affecting that couple, he refused to vote to repeal those WOTUS rules. That's his record. That's what he did. And he claims that he represented the people. Well, he didn't. He had the chance to do it, and he didn't. What he'll tell you, well, we filed the brief. Congress isn't about filing briefs. Congress is about making the law that affects people. He didn't do it. So what is it I did instead? I joined with North Dakota challenging the Obama WOTUS rules, the ones that Raúl he voted against repealing. We also defended the Trump WOTUS rules, and we have joined this case. In fact, when we were litigating in the Court of Appeals on this matter, we were standing side by side with the couple up north. So we have a good record in WOTUS and the waters of the U.S., which is what the core of this issue is. So
thank you for explaining to me what that was.
Didn't do it.
Ms. Labrador.
Wait. Let me respond to
Congress vote. Let's just do this real quick.
Yeah, I voted for it. I voted for it in committee. I advocated for it committee, voted for it on the House floor. I believe at one point it was tied to another bill that was a larger omnibus bill. And this is what people like Lawrence do. You know, they play these political games that they say that I voted. I was actually one of the strongest advocates on this issue. And that's why I joined the family and I voted for this issue every single time. So for him to say that I didn't vote on it, it's just absolutely not true.
And you refused to vote for its repeal. That's the record.
That's not true. That's not true, Lawrence. That's not true.
That's the record. That's your record, Raúl.
Mr. Macomber, you want to weigh in on WOTUS here for a second?
Yeah, you know, I'm going to weigh in on WOTUS and then I'm going to get over my head, because what I really want to talk about is this theory of Texas versus Pennsylvania. The first thing is,
unfortunately, I'm not sure we have time to dive into that. And unless you want to take your final.
It's actually very simple. There's only 2 questions. There's only 2 statements about it. One is that only 7 of 9 justices threw it out for standing. And second of all, Idaho broke the same rule that the 4 dependent states wrote in Article 1, Section 4 of this federal constitution in March 2020, when Idaho's Attorney General actually helped Governor Little and the Secretary of State alter Idaho's voting rules unilaterally without legislative assistance. That was clearly against the federal constitution. And that's why I think he didn't want to join Texas versus Pennsylvania.
All right, we're gonna hold off on another second here. Let's not introduce new things as we're trying to finish on time. But Mr. Wasden, I think you should get a shot at a quick response to that if you like. See, it's bedtime. It's bedtime, everybody. Did you want to, are you in good shape? Okay, let's get to closing. And it's 7:55. Let's do 2 minutes each. I'm going to hold up my finger at 1 minute and 3 fingers at 30 seconds. Does that make sense? That way I don't have to interrupt you. And we'll get rolling here first with Mr. Wasden.
The choice here is very clear. You can choose the Idaho way, or you can choose the DC Beltway. You can choose an AG that follows the law, or an AG that thinks he's still in Congress, and an activist and a policymaker, and that this office should be political. I'm not running for Congress. I don't think I'm a congressman. I'm not running for AG so I can use it as a stepping stone to be the governor. I'm not trying to get my face on Fox News. I call legal balls and strikes fairly and squarely. I don't waste your time by throwing you a curveball or your trust. I don't shade the truth just to score political points. It either meets constitutional muster or it doesn't. My duty is to tell people what they need to know rather than what they want to hear. I'm the only prosecutor running, and I protect children from internet sexual predators and our seniors from scam artists. I'm endorsed by former governors and former AGs. Abraham Lincoln said, put your feet in the right place and stand firm. That's what I've done. That's what I'll continue to do. And that's my promise to you. I ask for your vote.
Didn't even need the full 2 minutes. Thank you, sir. Mr. Macomber, you are next.
Thank you very much. First of all, thank you to the City Club for this spirited debate. Maybe a little
Always
too much
spirited.
inside baseball on the construction of the office, et cetera. But this is a tough race, and voters have a tough choice. I want to leave the viewers tonight with one thought, and that is this. I really do not need this job. I got out of the courtroom and into this race voluntarily because Idaho's in trouble. There are all means of forces entering Idaho today intent on undermining our civil liberties, our churches, and even our families. In my view, the most disturbing of these is the sexualization of our children's school curriculum. The Attorney General occupies a unique position to stop this disturbing trend in its tracks. As your next Attorney General, I commit to doing whatever it takes to rein in the educational establishment and get our schools back to the constitutional purposes of education, especially when Idaho continually fails in the basics at almost every grade level. Idaho needs a proven fighter in the Attorney General's office. The choice on May 17 is simple. You vote Macomber to fight executive overreach. You vote Macomber to strengthen state sovereignty. Vote Macomber to protect Idaho values. And you vote Macomber, or you suffer the corrupt Boise elite from these two insiders for another 4 years. Thank you.
All right. Thank you, Mr. Macomber. And Mr. Labrador.
Thank you, Greg, and thank you to Boise City Club, and thank you to the audience for watching and participating in this in this forum, which was supposed to be a forum. It turned a little bit more into a debate, but it's good to be with you guys. You know, Idaho needs a new Attorney General. We've had the same Attorney General for 20 years. He believes that his job is to represent the bureaucracy, to defend the bureaucracy and the government. I think the job of the Attorney General is pretty simple, is to defend the people of Idaho from Biden's liberal agenda, is to defend Idaho citizens from the federal and state government overreach, is to defend Idaho citizens from unconstitutional mandates, is to defend Idaho citizens from crime and from illegal immigration, is to defend the Second Amendment is to defend life and our children, and is to defend the people of Idaho, not the bureaucracy. I have a record. My record shows that I stand up for the people of Idaho, that I stand up for your liberties, that I stand up for your rights, that I'm a fighter, and I'm willing to take on the establishment and take on even special interests. I think Idaho does not need a person who's just sitting there, just calling balls and strikes. Idaho needs a strong attorney general, a strong, aggressive attorney general. There's some big fights happening in the United States. You have the Biden administration trying to take our sovereignty and our rights, and having somebody just sitting there calling balls and strikes is not what Idaho needs, because what we're going to do is we're going to watch the state of Idaho actually lose all of the things that are important to us. I'm Raúl Labrador, and I would love to be your attorney general. I would love to have your support. Thank you very much and have a good evening.
All right. Well, thank you to all three of you for spending the night here with us at the City Club of Boise. I think you're right. I think that was, you get as close to a conversation as you could get. And things are always a little tricky, especially at this stage of any election. And thank you all for treating each other with as much respect as possible, and to the audience for tuning in. And one last reminder, you've got looks like 4 more hours of Idaho Gives. There's a lot of good that can be done out there with Idaho's nonprofits between now and at midnight. So please keep that in mind. And once again, thank you all. And I think we will call it a night.
Good night,
Thank you,
Raúl.
Greg.
Good night, Art.
Good night.
Appreciate
Good night,
it.
everybody. Thank you.